Thanks a lot for having me, Tom. My name is Severin Vetter. I'm from Austria. I live in Vienna. I studied law at the University of Vienna, and my main interests are international law, constitutional law, with a special focus on environmental law, energy law, agricultural law, among others. And today I'm going to be talking about the human right to a clean environment. And but before we start, I'd like to say a few words for those who haven't heard about this before. So if a state deliberately pollutes the environment and harms people's health, that is, of course, a human rights violation, and it already is under current international human rights law. So if the state acts in a way that endangers people's health or their lives, then that's a violation of the right to life, no question about it. But what those who are now calling for a human right to a clean environment are trying to get at is actually something pretty different. This is about recognizing a right to lower CO2 emissions. And the question is your government obliged to adopt policies to lower CO2 emissions because you have a human right to low CO2 emissions? Now, if CO2 emissions, or rather low CO2 emissions, if low CO2 emissions are a human right, could opening a new factory be a human rights violation? Could driving a car be a human rights violation? So what we'd be doing by making the right to a clean or CO2-free environment a human right would be to basically subordinate our entire legal system, our entire economy, to this goal, reducing CO2 emissions. And that is what the most radical proponents of this idea want to achieve. And especially here in Europe, we now have a thing called the Green Deal. We're already heading in that direction. Everything must be subordinated to the goal of achieving net zero by 2050. So if this were to become a human right, it would no longer just be a political goal that states have set themselves. It would be an obligation under international law, and everything else would be a violation of a human right. Now, needless to say, many other rights and freedoms would suffer greatly if such a right were to be recognized. First and foremost, private property and free enterprise, the basis of our prosperity and our freedom here in the West. Freedom and property are, of course, intrinsically linked. Freedom without property isn't worth very much. I mean, what is the freedom of movement worth if you can't afford a car or a bicycle? What is a free press worth if you can't afford a printer to print your opinions? So I think that's a very, very important point to make. And what we're likely to see as the consequence of recognizing such a right to a clean environment is an avalanche of lawsuits, governments being sued every time they grant a permit for a new factory or even a road. So this new phenomenon that over the last few years has become known as climate litigation would reach a whole new dimension. Now, meanwhile, while Europe's main goal is to be carbon neutral by 2050, the priorities being set by the Chinese government are very, very different. China has for the last decades been pursuing an agenda known as the 100-year marathon. The goal is for China to become the world's #1 economic and military superpower by 2049, which is the 100th anniversary of Mao's 1949 communist revolution. And this plan was more or less kept secret for a long time. And actually most in the West aren't even aware that this exists. But Xi Jinping spoke about this very openly at the Communist Party's National Congress in 2017 in a 3.5-hour-long speech. And the Chinese are doing what is necessary to achieve this goal. They need cheap energy, so they're opening new coal plants every week. They're also building like crazy. About 15% of the world's greenhouse gas emissions come from steel and cement, as we know. So they're emitting all the CO2 they want. About 30% of global emissions come from China. And obviously, that gives them a huge competitive advantage. What we're doing here in the West with this green agenda is we are handing world dominance to the Chinese Communist Party on a silver platter. And we even did them the favor of choosing the same time frame until 2050, or rather 2049 for them. So what I would say is the West needs to wake up, because even if one believes the idea that CO2 is an existential threat to humanity, which I don't believe, but even if one does believe that, I think it's probably still better to live on a planet that is 1 or 2 degrees warmer than on a cold planet dominated by the Chinese communists. But let's get back to the international human rights side to all of this. First of all, what is international law? International law is the set of laws, customs, and principles governing the relations between states. The main sources of international law are treaties and international customary law. These treaties and customs will typically regulate questions of war and peace, which has traditionally been the most important aspect of international law, but also things like peaceful territorial disputes, trade, the high seas, and so on and so forth. But is there also a place for the individual in international law? And if we look at our modern international law regime, the answer must, of course, be yes. Over the last 100 years or so, we've seen a number of international treaties being adopted that govern the obligations of states towards individuals. I speak, of course, of the many human rights treaties, beginning with the 1948 Universal Declaration of Human Rights. Then we had the European Convention on Human Rights in 1950, the International Covenant on Civil and Political Rights, and the International Covenant on Economic and Social Rights in 1966, the American Convention on Human Rights, known as the Pact of San Jose in 1969, and so on and so forth. But this idea isn't as new as it seems. In fact, if we look at the early stages of international law in the modern era, it was actually this very question: do states have certain obligations towards individuals based on international law, that moved the Dominican legal philosophers at the University of Salamanca in the 16th century, most notably Francisco de Vitoria and Bartolomé de las Casas, to write about the fundamental rights that all humans enjoy and that all states must obey, like the right to life, personal freedom, property, and so on, in the context of the Spanish colonialization of the Americas. So regarding the question of human rights, they don't strictly govern the relations between states, but between states and individuals. Nevertheless, they're a very, very important part of international law. But before we go into the question whether climate change should have a place in the international human rights regime, I want to provide a brief overview of how climate change in general found its way into international law. And the key year in all this is 1972. In March of that year, the Club of Rome published a book called The Limits to Growth. This book was very influential at the time, and it kind of showed the direction in which leftist thought was to develop over the next few decades here in the West. And it was the first, or one of the first documents of its kind to mention climate change and the need to counter it. And it said, I have the quote here, "It is not known how much CO2 or thermal pollution can be released without causing irreversible changes in the Earth's climate, or how much radioactivity, lead, mercury, or pesticide can be absorbed by plants, fish, or human beings before the vital processes are severely interrupted." Now, there had been a few scientific studies that had mentioned human impact on the climate, But this book did a lot to introduce this kind of alarmist political language into the public debate. Like we read here, irreversible changes in the Earth's climate. That's the typical kind of alarmist language that we hear every day now, in fact, from environmental activists nowadays. But what this book did was it helped set the tone for a very important event that took place 4 months after this book was published in the summer of 1972, and that was the Stockholm Conference on the Human Environment. At this conference, two very important documents were adopted: the Stockholm Declaration and the Stockholm Action Plan. The Stockholm Declaration consists of 26 principles that were then later on to become the basis of modern international environmental law. And the action plan contains 109 recommendations to states on how they can work to improve their environmental policies. And if I'm not mistaken, this is the first time that the climate was mentioned in an international legal document. This was a recommendation 70 of the Stockholm Action Plan. It says it is recommended that governments be mindful of activities in which there is an appreciable risk of effects on climate. Then also in 1972, the United Nations Environment Programme was founded, and ever since, UNEP has kind of been the driving force behind the development of international environmental law. Then in 1977, the Convention on Long-Range Transboundary Air Pollution was adopted, and in 1985, the Vienna Convention for the Protection of the Ozone Layer followed. And this is where we see the first attempts in international law to regulate greenhouse gas emissions, because in 1987, a protocol to the Vienna Convention for the Protection of the Ozone Layer was adopted at Montreal, the famous Montreal Protocol, which already contains measures to reduce emissions of certain greenhouse gases. Then in 1988, the Intergovernmental Panel on Climate Change was established. This was the same year in which James Hansen, the famous NASA scientist, testified before the US Congress, and global warming started to also become a major issue in American domestic politics. Also in 1988, the UN General Assembly adopted Resolution 4353, in which it said that the UN recognizes that climate change is a concern of mankind and determines that necessary and timely action should be taken to deal with climate change within a global framework. Then the United Nations Environment Programme made this decision 1536, and that then sparked the beginning of preparations for such a framework. And then the General Assembly called or convened a global summit for this purpose. And this was, of course, the famous Rio Summit held in Rio de Janeiro in 1992. It was attended by representatives of 179 countries, and 5 important documents were agreed upon there. First, the Rio Declaration on Environment and Development, with its 27 principles. This was basically a newer version of the Stockholm Declaration. And actually, a noteworthy detail of the Rio Declaration is its principle 15, the so-called precautionary principle. This introduced for the first time the idea that, I quote, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures. Now, the other documents are the United Nations Framework Convention on Climate Change, the UN Convention on Biological Diversity, and the Forest Principles, and Agenda 21. Agenda 21 is a non-binding action plan that talks about socioeconomic aspects of fighting climate change, measures to fight desertification, deforestation, water pollution, and so on and so forth. And the Framework Convention on Climate Change is a treaty on reducing greenhouse gas emissions. It divides the world into two categories, basically. So you have Annex 1 countries and you have Annex 2 countries. All of them are supposed to adopt national policies to reduce greenhouse gas emissions. And in addition, Annex 2 countries are supposed to provide developing nations with financial support to help them implement these policies. And ever since, a conference of the parties has been held every year, the famous COPs. This year we will have COP29 in Baku in Azerbaijan. But in 1997, COP3 was held in Kyoto in Japan. And this is where the famous Kyoto Protocol to the United Nations Framework Convention on Climate Change was adopted. It entered into force in 2005, and it contained very specific emission reduction goals. So you had countries listed in Annex 1 of the Framework Convention. They were supposed to reduce their emissions by at least 5% below 1990 levels within the first commitment period that was to last from 2008 to 2012. And Annex B to the Kyoto Protocol lists about 40 countries with their individual quantified emission limitation targets. The United States, it is important to note, never ratified the Kyoto Protocol. Canada withdrew in 2012. Nevertheless, that same year, COP18 was held in Doha, and that's where the Doha Amendment was adopted. That triggered a new commitment period from 2013 to 2020. And this time, the new goal was to reduce emissions by 18% below 1990 levels. 1 year previously, however, at COP17 in Durban, the decision was made that the Kyoto Protocol should be replaced by a different instrument after the end of the second commitment period. So at COP21 in 2015, this was in Paris, the Paris Agreement was adopted, and the Paris Agreement now no longer contains specific goals for each country, but one big global goal, so to speak. And this is Article 2 of the Paris Agreement. It says the objective is to reduce, I quote, the increase in the global average temperature to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees Celsius above pre-industrial above pre-industrial levels. Now, the way countries are to achieve this is by setting themselves their own emissions reduction targets. And they are then supposed to submit these emissions reduction targets to the United Nations Framework Convention on Climate Change Secretariat every 5 years. And these are known as NDCs, nationally determined contributions. But states can freely decide what these nationally determined contributions are. The only restriction that the Paris Agreement places on them is that every NDC has to be more ambitious than the last, so they can't be retrogressive. But there is, of course, a large number of activists and NGOs and people who profit financially from this whole green agenda, like Al Gore, for instance, who believe that this doesn't go far enough. And we should have a binding international treaty forcing states to adopt certain measures. Now, obviously, many countries would be very hesitant to join such a treaty. In fact, the voluntary nature of the obligations under the Paris Agreement were the main reason for this near universal membership of the Paris Agreement. 195 states have ratified it so far. Even North Korea has ratified the Paris Agreement. If I'm not mistaken, Syria is currently the only country that hasn't ratified it. But as I mentioned in the beginning, treaties are not the only source of international law. There's also a thing called international customary law. And the question that leftist environmental lawyers are now asking is there already an existing obligation for states to implement certain more radical green policies under customary international law? Or can we at least say that such obligations can be deduced from the treaties that are already in place? Now, for usage to be considered binding international customary law, you need two things: state practice and opinio juris. State practice needs to be constant, extensive, and virtually uniform, and it needs to be based on opinio juris, which means that states need to engage in a certain practice, not out of pure political habit, but out of a sense of legal obligation. Now, given that, as we've seen, the current international climate regime centered around the Paris Agreement is largely voluntary, wouldn't it be absolutely great if there were something in international law that allowed individuals, say climate activists or NGOs, to force states to adopt greener policies? And wouldn't it be even better if one could argue that obligations to drastically reduce CO2 emissions or switch to renewables or whatever already existed, say in international customary law? Now, human rights are a very important part of international customary law. There is consensus today that large parts of the 1948 Universal Declaration of Human Rights have become binding international customary law. UN General Assembly resolutions are usually non-binding, but because of constant, extensive, and virtually uniform state practice motivated by opinio juris, several of the rights codified in the declaration are now considered to be binding international law. For instance, the right to be recognized as a person before the law, or equality before the law, and quite a few others. So the unique thing about international human rights law is that it gives individuals the right to take their country to court, to an international court that is, if they feel that that country has violated a human right. And there are several regional human rights conventions and regional human rights courts. In Europe, we have the European Convention on Human Rights with the European Court of Human Rights in Strasbourg. In the Americas, you have the Pact of San Jose, the American Human Rights Convention, with the Inter-American Court of Human Rights in Costa Rica. And at the UN level, individuals can apply to the UN Human Rights Committee if they feel that their rights under the International Covenant on Civil and Political Rights have been violated. So human rights law gives individuals this possibility to take their states, their governments, before international institutions, international courts, and force them to end certain policies, or indeed to force them to adopt certain policies in areas where state inaction could be seen as a violation of a human right. Just to show what this would mean, if a country didn't criminalize murder, for instance, that country would be violating the right to life. If a country failed to criminalize theft, that country would be violating the right to property. So state inaction can also be a violation of a human right. So the question is state inaction on climate change a violation of a human right? Now, if a government were to pour poison into a lake, that would obviously violate the right to life and physical integrity of those living near that lake. If the lake is privately owned, it would also violate the right to property of the owner of the lake. The same would go for a state that failed to criminalize or punish such behavior by a private sector actor. For instance, in the famous Lopez Ostra case, the European Court of Human Rights held that pollution that prevented an individual from living in their house was a violation of the right to privacy, and that the state has an obligation to prevent that kind of pollution. And I believe that makes sense, The same goes for the Öner Yildiz versus Turkey case, where the court held that the state had violated Article 2, that is the right to life, by not informing people and not protecting them from a methane explosion. And I think that makes sense too. But the main concern of today's global climate agenda is, of course, CO2. And in my opinion, it's hard to argue that anyone could be violating someone's right to life or property or privacy just by emitting CO2. Because in order for a state to be responsible for a human rights violation, it has to have caused that violation, either by action or inaction, but it has to have caused that violation. And that causality has to be proven. But it's impossible to prove that CO2 emissions from a specific factory or a specific region or a specific state caused any specific harm to the environment. However, this has not kept lawyers from arguing precisely that a lack of measures to significantly reduce CO2 emissions violates the right to life and other rights, especially the right to privacy. In fact, there has recently been a very prominent decision from the European Court of Human Rights that went precisely in that direction. In Klimaseniorinnen versus Switzerland, the European Court of Human Rights ruled that the absence of certain measures is a violation of the right to privacy. Now, the right to privacy has always been understood to encompass the right to physical integrity, so an obligation on the part of the state to not do anything that could harm people's health, and also to enact laws that will keep private actors from damaging people's health. The Klimaseniorinnen, which translates as Old Ladies for the Climate, are an association of elderly women in Switzerland who are worried about climate change. And they're over 60, so they believe that they're more at risk from heat waves than other people. And the court ruled in their favor, saying that the fact that Switzerland wasn't doing enough to fight climate change was a violation of their right to privacy under Article 8 of the European Convention on Human Rights. And the court said, and I quote here, "Drawing on the above considerations and having regard to the causal relationship between state actions and/or omissions relating to climate change and the harm or risk of harm affecting individuals, Article 8 must be seen as encompassing a right for individuals to effective protection by the state authorities from serious adverse effects of climate change on their life, health, well-being, and quality of life." The court went on to establish 5 criteria that a state party to the Human Rights Convention must fulfill in order not to be in violation of Article 8. A state must adopt general measures specifying a target timeline for achieving carbon neutrality and the overall remaining carbon budget for the same time frame, or another equivalent method of quantification of future greenhouse gas emissions in line with the overarching goal for national and/or global climate change mitigation commitments. B, states must set out intermediate greenhouse gas emissions reduction targets and pathways that are deemed capable in principle of meeting the overall national greenhouse gas reduction goals within the relevant timeframes undertaken in national policies. C, states must provide evidence showing whether they have duly complied or are in the process of complying with the relevant greenhouse gas reduction targets. And D, states must keep the relevant greenhouse gas reduction targets updated with due diligence and based on the best available. E, they must act in good time and in an appropriate and consistent manner when devising and implementing the relevant legislation and measures. So if we look at A, this is very interesting because it basically says that the right to privacy under Article 8 is from now on to be interpreted as a state obligation under human rights law to fulfill, as it says here, national and or global climate change mitigation commitments. So if you're living in a country that is party to the Paris Agreement or is a member of the European Union and therefore subject to the EU's Green Deal, it is your human right that your government should meet the targets laid out in those conventions. Now, of course, this is a pretty big stretch, and the judges clearly overstepped their boundaries with this judgment. They overstepped the boundaries of the separation of powers. In my opinion, they have absolutely no business making up these sort of right. But here we are anyway. And what is interesting, though, is that there was a dissenting opinion by Judge Tim Eike. He's German, but he's the UK's nominee to the European Court of Human Rights. And he wrote the following, quoting here from paragraph 3 of his dissenting opinion: I have come to the conclusion that the majority in this case has gone well beyond what I consider to be, as a matter of international law, the permissible limits of evolutive interpretation. So what this basically means is he's saying that the idea that the right to privacy encompasses a right to radical environmental policies is a product not of proper jurisprudence, but of his colleague's imagination. He goes on to say, as is clear from the historic refusal of the contracting parties to the convention, to respond positively to the repeated calls by the Parliamentary Assembly of the Council of Europe for the adoption of an additional protocol to the convention, which would provide for a right to a clean and healthy environment, even if this issue was not perhaps considered at the time of the drafting of the original convention. The omission from the convention as it stands today of such a right was not coincidental. And this is extremely important because here he's saying that not only does the right to privacy not include this so-called right to a clean and healthy environment, in fact, the states party to the Human Rights Convention rejected efforts in the Council of Europe to amend the convention in order to include such a right. So it was deliberately not included. Nevertheless, the judges just decided to pretend that it was included. Now, the efforts to include such a right in the Human Rights Convention have been growing. So I'm talking about the efforts to include an explicit right to a clean and healthy environment. So one would not have to rely on the right to privacy anymore. And members of the Parliamentary Assembly of the Council of Europe have repeatedly called for such a right to be adopted. Then also the Reykjavik Declaration, adopted at the Council of Europe Summit in Reykjavik in May 2023, called for this, but no amendment to the convention was made so far, so the judges had to make use of what they had, which was Article 8, the right to privacy. But what are the consequences going to be? This is a quote from an article published by a leftist think tank called the Universal Rights Group. And this is what they say: such recognition of such a right would provide legal coherence and certainty, as it would allow the court to issue binding rulings that would lead to increased enforcement of state obligations and the implementation of concrete measures to protect the right to a clean environment, including for those most at risk, as well as environmental human rights defenders. It would consolidate both the procedural and substantive elements of the right at a regional level. In doing so, it would help bring domestic regimes into line with one another, and at the same time, a comprehensive system of regional safeguards could incentivize increased protection at domestic level. So what do we see here? It says, as it would allow the court to issue binding rulings that would lead to increased enforcement of state obligations and the implementation of concrete measures to protect the right to a clean environment. That is exactly what happened with the case of the old ladies in Switzerland. Individuals should be able to force their governments to comply with supranational climate policies or climate policies that they inherited from previous governments. They then talk about protecting environmental human rights defenders. Now, we often hear these stories about evil landowners in South America or evil oil companies using violence to stop environmental human rights defenders from protecting the environment. But what I'm afraid of is that this actually might mean an effort to criminalize any kind of resistance or criticism of the agenda put forward by these so-called environmental human rights defenders. And we all, of course, know very well who is meant by this. Greenpeace, Friends of the Earth, Extinction Rebellion, all very well-funded, politically influential organizations that are pushing an agenda that is absolutely lethal for the West. But to get back to the Universal Rights Group's article, it says they want to bring domestic regimes into line with one another, and they want comprehensive comprehensive system of regional safeguards. Now, what this means is that introducing such a right to a clean environment would help to circumvent decision-making by national elected lawmakers who can be held accountable by the voters, and to make it easier to impose radical climate change policies on sovereign states. And this is very clear in the case of Switzerland, because the Swiss actually had a referendum in June of 2022 where they rejected a proposal to amend the Swiss CO2 Act in order to include more radical climate change policies. But the European Court on Human Rights is now trying to force them to adopt precisely these measures that they rejected at the referendum anyway. But back to the Universal Rights Group's article. It says, recognizing a right to a clean environment as a standalone right could open up further avenues for climate litigation and increase chances of success, which could in turn translate into more comprehensive and consistent protection across the continent. These new opportunities for climate litigation could have significant implications for business actors and accountability for the human rights impacts of their activities. Victims of business-related environmental violations would have a more solid claim to seek remedy, while businesses would have more incentives to comply with existing standards, especially considering the financial and reputational risks and costs associated with climate litigation. So this would help not only to coerce states, but also to harass businesses. And you get one guess as to where these companies are going to go. Many of them are, of course, going to go to China. Now, most European countries already meet the criteria outlined by the European Court of Human Rights in the Swiss old ladies case. The UK has its famous net zero policy with its famous, or I should rather say infamous, Climate Change Act. The EU has its Green Deal, and Switzerland is now going to have to comply with this, although there have been some members of the Swiss parliament who are trying to resist this. In fact, the Swiss lower house voted to reject the European Court of Human Rights judgment last month. So I'm very excited to see how this is going to go. I hope they prevail. But this is, of course, only the situation here in Europe. On a global level, that is to say at the UN, the idea that there is a standalone human right to a clean environment actually goes back all the way to the Stockholm Conference in 1972 that I mentioned before. Principle 1 of the Stockholm Declaration says, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of a quality that permits a life of dignity and well-being. But 20 years later, in 1992, Principle 1 of the Rio Declaration said, human beings are at the center of concerns for sustainable development. They're entitled to a healthy and productive life in harmony with nature. So while the Stockholm Declaration used the word right, the parties at the Rio conference deliberately chose to use weaker language, stating merely that humans are entitled to live in harmony with nature, but not mentioning anything about human rights. Both the Stockholm and the Rio declarations are non-binding documents that are intended to provide guiding principles for interpreting international environmental law. But some of these principles have, in the meantime, reached the status of international customary law. Like, for instance, the polluter pays principle, which is principle 16 of the Rio Declaration. Some also argue that the principle of environmental impact assessment, that's principle 17 of the Rio Declaration, has also to some extent become an obligation under international customary law. And the same goes for a few of the other principles in the Rio Declaration and also the Stockholm Declaration. And it's actually precisely this development that was foreseen by those who drafted the Rio Declaration. They knew that a lot of what they were putting into the declaration was likely to find its way into international customary law after a while, and so they deliberately chose not to include language that would suggest that they believed there to be a human right to a clean environment. This was a clear step away from the language that had been used in the Stockholm Declaration, and it was in fact the US who insisted very strongly back then during the negotiations that no mention of a human right should be made in Principle 1 of the Rio Declaration. 2 years later, in 1994, a woman named Fatma Xentini was appointed UN Special Rapporteur for Human Rights and the Environment, and she drafted a declaration on human rights and the environment that would have included a human right to a clean environment, but this declaration was rejected by the UN's Human Rights Commission. And again, the US played a decisive role in stopping this declaration from being adopted. This process of trying to create such a right started to gain pace again in 2012, when an American international lawyer called John Knox was appointed by the UN Human Rights Council to the newly created position of independent expert on human rights and the environment. And it was his job to come up with a report on this question of human rights and the environment. This report was published in 2018, and it was called Framework Principles on Human Rights and the Environment. And what Knox did, first of all, was to analyze regional human rights treaties and national constitutions to find examples where a right to a clean environment was already recognized. According to one source that he quotes in one of his papers, more than 75 national constitutions recognize this right. His successor as UN Special Rapporteur for Human Rights and the Environment, John Boyd, claims that this is the case in more than 100 national constitutions. I really don't believe that at all. I strongly doubt that. I don't think that's true. But there are some examples on a regional and national level as well. The San Salvador Protocol to the Pact of San Jose, for instance, says that everyone shall have the right to live in a healthy environment and to have access to basic public services. And there are also some national constitutions that include this right to a clean environment. A prominent example is the Constitution of Ecuador, adopted in 2007 under the radical socialist president Rafael Correa. Interestingly, in 2023, Chile rejected a new constitution in a referendum that would have included a human right to a clean environment. And in 2021, the state of New York amended its constitution, and Article 1, Section 19 of the State Constitution of New York now says that each person shall have a right to clean air and clean water and to a healthful environment. So there are some examples on a national level, but back to the UN, the work of these special rapporteurs that I mentioned before seems to have had quite some significant impact, because in October of 2021, the UN Human Rights Council adopted a resolution recognizing a human right to a clean, healthy, and sustainable environment. That was Resolution 4813. And this was then followed by a resolution of the UN General Assembly in July of 2022 that echoed the Human Rights Council's decision, also recognizing this right. This was Resolution 76-300. But these resolutions are, of course, non-binding. So the General Assembly passed another resolution requesting an advisory opinion of the International Court of Justice on the obligations of states in respect of climate change. And these are the exact questions that the General Assembly wants the ICJ to answer. What are the obligations of states under international law to ensure the protection of the climate system from anthropogenic emissions? And B, what are the legal consequences under these obligations? So the General Assembly is basically asking the International Court of Justice to confirm what it has been trying to achieve through Resolution 76-300, the resolution from 2022 that recognizes a right to a clean environment. And it wants it to confirm that this has become binding international customary law. We'll see what the ICJ will say. ICJ advisory opinions are also non-binding, but they carry a lot of weight in international law. And it's very, very difficult for lawyers to argue against the ICJ. So we'll see what they will end up telling us in their advisory opinion. This is going to be very interesting, especially given that this isn't the first time that an international court has been asked for an advisory opinion on this matter. In fact, in 2022, a group of countries called the Commission of Small Island States on Climate Change and International Law requested an advisory opinion from the International Tribunal for the Law of the Sea in Hamburg, asking the following question: what are the specific obligations of states parties to the United Nations Convention on the Law of the Sea to prevent, reduce, and control pollution of the marine environment in relation to effects that result or are likely to result from climate change? And the court has already issued its advisory opinion, and it said that states parties to the United Nations Convention on the Law of the Sea have an obligation to, I quote, take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions. So according to the International Tribunal on the Law of the Sea, there is such an obligation to reduce CO2 emissions. It doesn't explicitly say that there is a human right to a clean environment, although the UN Special Rapporteur on Human Rights and Climate Change, Ian Fry, the UN Special Rapporteur on Toxics and Human Rights, Marcos Orellana, and the UN Special Rapporteur on Human Rights and the Environment, David Boyd, submitted a so-called amicus brief asking the tribunal to use human rights language in its advisory opinion. In the end, what the tribunal said was this: the tribunal notes that climate change represents an existential threat and raises human rights concerns, but it doesn't explicitly recognize a human right to a clean environment, which wouldn't fall within its scope of jurisdiction anyway. Now, in 2023, Chile and Colombia requested an advisory opinion from the Inter-American Court on Human Rights on the obligations of OAS members to adopt measures to reduce CO2 emissions. The Inter-American Court of Human Rights already issued an advisory opinion on this question in 2017, and just a few months ago, it ruled in La Oroya versus Peru that Peru had violated the right to a clean environment by not doing enough to protect its citizens from pollution being caused by a metallurgical facility in the Sierra Central region in Peru. So I think it's pretty obvious what this new advisory opinion is going to say. It's probably going to specify the meaning of Article 11, of the San Salvador Protocol that I mentioned before, and it's very likely to contain similar criteria like the ones established by the European Convention, the European Court on Human Rights, in the case of the old ladies in Switzerland. So basically, the whole world is headed in this direction. It is, however, important to note that Resolution 76-300, that was the UN General Assembly resolution that recognized the right to a clean and healthy environment, was adopted with 161 votes in favor and 0 votes against the resolution. But there were 8 countries who abstained: Belarus, Cambodia, China, Ethiopia, Iran, Kyrgyzstan, Russia, and Syria. And now, we will obviously see what the ICJ will say, but should the ICJ come to the conclusion that the right to a clean environment already exists under international customary law, these states who abstained are going to argue that by abstaining, they showed that they don't agree with this idea, that there is a right to a clean environment, and that there was no state practice and no opinio juris on their part that would suggest that they should also be subject to these new emerging obligations under international customary law. So whatever the ICJ says, China is not going to be affected. But what does this mean for us here in the West? I've already mentioned that we're going to see a lot more climate litigation. This is going to lead to a lot of uncertainty because the right to force your government to reduce CO2 emissions is based on an extremely vague concept, and it's ultimately aimed at achieving a goal that cannot be achieved. So what we see here is in fact actually what we saw in the Switzerland case. Even if Switzerland were to stop reducing CO2 emissions altogether, that would reduce global emissions by 0.085%. It wouldn't make any difference at all. So if Switzerland, a country that because of its size can in no way possibly have any effect on the global climate whatsoever, can be declared to be in violation of the human rights of a group of old ladies who are worried about heat waves, then that just doesn't make any sense at all, in my opinion. So we need to resist this. The West needs to summon up the courage to admit that it is heading down the wrong path. This is absurd. It's unscientific. It's destroying our prosperity. It's destroying our freedom. It's completely messing up our legal system. It's doing a lot to help China achieve its goal of world dominance by 2049. This needs to end, and it needs to end now. Thank you very much for your attention.
In the big picture, what do you see happening in Europe in terms of the people rising up against this and saying, no, you're not going to shove this down our throats? Are you seeing any signs of that happening?
Yes, I am seeing signs of that, thankfully. But, there could always be more. But I do think that people are increasingly asking the right questions. And if you look at the whole climate debate, we've been hearing these alarmist predictions for decades now. We heard Al Gore tell us in 2007 that the North Pole would be completely gone by 2015. We've had people since the 80s and 90s telling us that the Maldives would be underwater by the early 2000s. None of this has actually happened. And I think the people are starting to realize that these predictions are greatly exaggerated. And what they're seeing above all is that everything is getting more and more expensive. We were promised green jobs. We were promised a bright green future. What we're getting is greenflation and green poverty. And I think more and more people are realizing this. But of course, there could always be more resistance. And but I do hope that people are going to wake up more and more.
How about the media landscape in Austria? Do you think people are just buying into whatever legacy media there is, or are people listening to podcasts and looking at X and all this other stuff?
Yeah, obviously there are, informed people who are listening to podcasts and who are active on Twitter and so on. But I think what we see above all is that it's actually sort of the simpler people who are waking up to this much more than the so-called intellectual elite, because it's very fashionable to be green, and it's very fashionable to drive an EV and all that sort of stuff. But it's the people whose food is getting more expensive, whose rent is going up, whose food prices are rising. They're the people who are realizing what this whole green agenda is leading to, and they're actually the ones who are saying that this needs to stop. That's the impression that I'm getting.
Do you have the impression that those elites actually do believe it then? It's not just that they know it's all bullshit, but they're pretending to believe? I wonder.
Yeah. Well, I'd say that most of them probably don't really care. I mean, this is the fashion, and most people just do what's fashionable, basically. That's the impression I get.
Okay. Any other points you'd like to make before we wrap this one up?
Yes. Speak up, resist. I mean, as I said before, we're handing global dominance to the Chinese Communist Party on a silver platter. And if we don't end these radical green policies in the West here soon, we will end up in a world that is dominated by China. And I don't think anyone could possibly wish for that.
All right. Thank you very much, Severin Vetter. We'll talk to you next time. Bye.
Thank you. Bye.